Land Use Law Update panel. This is a panel that we have done for several years. We're kind of the three amigos at this point because it's probably our fourth or fifth year of doing this, and we have a great deal of fun. There's always a good number of cases to talk about. I want to introduce our panel to people who may not know us. My name is Nancy Stroud. I'm with the law firm of Lewis, Stroud & Deutsch. I practice mostly for local governments in land use law, and I'm wearing all sorts of things. This conference on FAICP this year and 30-year member, which is one of the more fun things about being here at the conference. David Theriac is with Theriac in Spain in Tallahassee. David's a land use lawyer and practices all over the state. He is based in the northwest part of the state, and has a very strong background in litigation. When I'm looking for a litigation attorney, I often call David and say, "Are you interested in this case?" Susan Trevarthen is with Weiss Serota Helpman et al. In Fort Lauderdale in Miami, a land use attorney, very accomplished FAICP. And I'm sure you've heard, I know you've had a panel already.
Tomorrow.
Oh, we have another panel tomorrow, but Susan's a go-to person when you want to learn about planning law. So today I'm going to start off, and I want to cover two cases that the APA Florida has entered amicus briefs on. So they're what APA has considered to be important land use cases for the state of Florida. And the first case I've covered over several years, but it's becoming one of those really long-running cases. I think this may be the last year that we cover it because the plaintiffs have asked for the U.S. Supreme Court to take certiorari on it, and I doubt that the Supreme Court will take certiorari, but never know, with the new makeup of the court, if the court's going to be interested in redoing takings law. But this is the case of Caseta versus town of Ponce Inlet. Many of you may know the little town of Ponce Inlet, which is in the middle part of the eastern coast in Florida. And it truly is just a small little coastal village where back in 2003 it created a plan and regulations for the development of its very valuable, although basically undeveloped waterfront. And it created a riverfront commercial land use category in its comprehensive plan, limiting height and square footage of commercial buildings. And then enacted a zoning overlay district to implement the plan. After that, Mr. Caseta and his family began buying up riverfront parcels, and with some encouragement from the town staff and one or two of the council members over the course of years in discussing his plans, encouraged the town to create a mixed-use planned waterfront development that would allow the commercial development that he wanted. Never made an application for a comp plan amendment, a development order, or zoning change, but had an extensive series of discussions with the staff. So by 2008, the staff was beginning to consider the necessary comp plan amendment to enable at least part of this development and pass the comprehensive plan amendment on first reading. And then the citizens got wind of what was going on, and there was a big groundswell of opposition to the plan. And citizens put together a referendum to amend the town charter in a way that would effectively prohibit the development. And so the second reading comes up, the referendum passed, a new town charter, a new town council was elected, and when the comprehensive plan amendment came back for second reading, it failed. And that's where all of this started. There's a series of cases. The first case is a case in which Becerra challenged the referendum as invalid. By that time, you may recall the legislature passed a statute that prohibited referenda like this on parcels that are property that are 5 parcels or less. And this property was a composite of 14 different parcels, but altogether was 16 acres and was part of the plan for the mixed-use development, the whole parcel. And that's what the court found, that this was one parcel of 16 acres, and that one decision really made a difference in everything that happened in the decade following. So, town was without the charter, and it was with its old comprehensive plan and zoning regulations, and with another lawsuit where Becerra challenged the failure to adopt the comprehensive plan amendment that it wanted as a regulatory taking. And it went to trial court on that, and the trial court found a regulatory taking on 4 parcels and a Harris Act violation. And the town appealed that, and the 5th District Court of Appeal decided that there was no vested right on the part of the property owner for a comprehensive plan amendment, and therefore no Harris Act claim. Good to go. Except that there was the takings claim still out there. So it went back to the trial court, and the jury trial took place on the takings damages, and this little town of Constantine was stopped with a verdict of more than $30 million on the taking claim. Just as a note, APA got involved in Becerra 2 to make the point that there is no vested right in the comprehensive plan amendment that has not passed, and no vested right, therefore, for a Harris Act claim. The jury takings damages and the liability decision went back up to the 5th District Court of Appeal last year in 2017. And the 5th District reversed the takings claim, but said, we don't think that this is a total taking. You still have some reasonable use of your property, because after all, this is one big property and there are a couple of businesses on there already. We've already decided it's one parcel. You have to look at the whole parcel for a takings claim. But we're gonna let the trial court look at this once more and decide if there was a partial taking. And by the way, when the trial court looks at that, it should look at whether the takings claim was even ripe for the trial court to look at, or whether it would have been futile for the property owner to pursue its comprehensive plan amendment. So back to the trial court, and in April this year, a new judge in the case dismissed the takings claim, said it was not ripe, that you have to get a final decision before you could take a takings claim, and they never got the comprehensive plan amendment through the second reading. And Becerra actually never submitted an application for even a small scale amendment or rezoning, or even a vested rights application, which was available under the regulations. And it rejected the claim that such a submission would be futile because of council hostility, because the trial courts, there was no proof that the council was hostile to your proposal. So no damages, no attorney's fees. Except that the property owner did appeal to the 5th District, the Florida Supreme Court, to look at the takings decision. They were denied access and said there's no claim here we want to look at. And so now they're able to take a writ of certiorari to the U.S. Supreme Court. So the question is, what is the U.S. Supreme Court going to do in this case? Normally you would think it's pretty settled law here, pretty clear. You know, they never made an application. They're saying they should have, the town should have paid them because it didn't adopt its comprehensive plan amendment. This just doesn't compute under the law. But if you may remember, we had an odd case called Coons versus St. John's Water Management District, which is an exactions case brought up to the Supreme Court as a takings case, where the Supreme Court found that even though a permit was never issued with a condition, which could be challenged as an exaction, which had been the law up to Coons, the Supreme Court found just the fact that the negotiations with the Water Management District showed basically bad faith and extortion kind of scheme, you know, in the minds of some, that they were going to find that there was a constitutional violation here. And in fact, it's probably not a takings, but a due process violation. So who knows? I mean, the brief of Becerra to the Supreme Court says that they spent 6 years trying to appease the town. The district court was too rigid in its instructions that the trial court must determine if applications were meaningful. And in fact, what was happening here was that the town was intentionally devaluing their property with the intent of later acquiring it at a discount. In other words, you know, bad faith, bad actors, you should protect us against this. We'll see. I suspect that next year we'll say, we're not going to talk about ponds because it's over, but you never know. So some takeaways from this are that the town's persistence in this case, a little town like Poncelet, was remarkable because, as you can imagine, it was terribly expensive to litigate. Not many town councils would survive, or even town attorneys would survive that kind of odyssey. But they stuck with their guns. The importance of planners when they talk with developers and they're talking about applications and what's possible and what's not possible, making very clear that they're not making a decision here when it's the council's decision. We're trying to be of assistance, but we're not telling you what to do. We're not telling you what the council will approve or not approve. That kind of negotiation apparently is something that the courts may not really understand, and they might consider it extortion or bad faith or whatever. But the importance of the whole parcel principle, the fact that this 14 acres was considered one parcel, very, very important. So the question at the Supreme Court is whether it will revisit the ripeness and futility doctrines and revisit Penn Central, which is the case where most takings claims are litigated, and give more weight to the character of the governmental action rather than the owner's reasonable investment-backed expectations and other tests involved in Penn Central. Okay, on to the next case, which is a case that actually the national APA decided was a very important case nationally, and so joined the Florida APA in this case. And it's really about the consistency doctrine. When a development order is challenged as inconsistent with the plan, what in the plan has to be evaluated in terms of consistency? As you may have heard last year, if you attended this panel, the Second District Court of Appeal in the state determined in the Heine case that when a consistency challenge is brought, the only important aspects of consistency are whether the use, density, and intensity of the development order are consistent with the plan, ignoring that the plan includes much, much more than that. So that popped up in a case that came out of Miami, where the city of Miami had granted a rezoning of a vacant parcel that was on the edge of a historic district, which was residential, and the rezoning allows commercial uses. At the same time, which is pretty common, I guess, in Miami-Dade and cities in Miami-Dade, the offer proffered and the city accepted a restricted covenant that would limit height to 35 feet and require part of the project to contain residential use. This was all a part of trying to satisfy neighbors that the proposed rezoning and commercial development, the furniture store that was proposed, would be compatible with the residential district. And to do this, the city also had to adopt a comprehensive plan amendment changing the future land use designation to a commercial use. And so the neighbors brought a comprehensive plan consistency challenge under section 163.3215. And the neighbors claimed that the rezoning was inconsistent with certain enumerated goals in the plan, including goals in the housing element and goals in the land use element. And as you can see here, they are policies and goals related to protecting and enhancing existing viable neighborhoods, controlling large-scale and/or intensive commercial industrial land development, which may negatively impact any residential neighborhood. It's hard and not possible, really, for the neighbors to challenge the use designation because, as you recall, the city amended the use designation to allow commercial at the same time it did its rezoning. So the city moved for summary judgment, arguing that the statutory inconsistency challenge is limiting to enforcing only the comprehensive plan policies that govern use, density, and intensity. And so that these compatibility type of goals could not be enforced. They were basically irrelevant in a consistency challenge. And in November of last year, the court agreed with the city and granted summary judgment, meaning that it didn't go to trial, it didn't look at any factual disputes. It said, as a matter of law, we agree that the statute only allows a consistency challenge on those things. Well, I hope every one of you are kind of puzzled at this point, because we've had 20-some years, almost 30 years of consistency challenges where the courts have always looked at every policy in the plan, right? So this doesn't really compute, but here we have a second district court of appeal deciding it, and the third district, where the appeal here was happening, got the attention of a number of the planners on the state, and so we got involved. It accepted the city's argument based on Heine, found that the covenant renders the project compatible with the neighborhood and therefore consistent with the plan. So it said, well, we're going to find as a matter of law that we don't have to look at anything like compatibility, but we're going to decide also that it's compatible without taking any testimony or making any factual decisions. So it's been appealed to the third district, and we've joined the neighbors in saying that the Heine case was wrongly decided. It's not in accord with settled Florida law. It was incorrectly applied. Court failed to apply strict scrutiny, which is required, has been required since the Snyder case. And compatibility is a factual dispute that can't be decided on summary judgment. So look at the relevant statutes here. Look at the intent of the Comprehensive Planning Act. One of the intent phrases is that no public or private development shall be permitted except in conformity with the comprehensive plans or elements or portions thereof, not just use, density, and intensity. And then 3194 says, after a plan's been adopted, all development undertaken, all actions taken in regard to development orders shall be consistent with the plan or element, not just part of the plan, but plan or element. And then again in 3194, a development order or land development regulation shall be consistent with the comprehensive plan if the land uses, densities, or intensities, or other aspects of development permitted by such order are compatible with and further the objectives, policies, land use, densities, and intensities. So this argument is made in Hines. Look at what compatibility means here. Look what the intent of the statute is. But when you look at the statutory language that creates a consistency challenge in 3215, this is confusing to the court because it says that an aggrieved or affected party, adversely affected party, may maintain a de novo action to challenge any decision of such government granting or denying an application on a development order which materially alters the use or density or intensity of use on a particular property, which is not consistent with the comprehensive plan adopted under this part. And the court looked at this language and said, well, it's really only use, density, or intensity that can be an issue of inconsistency. So our argument and the argument of the plaintiffs and other amicus is that this section tells you what kind of development order you can challenge. You can't bring any development order to a consistency challenge. It has to be a development order that materially changes the use, density, and intensity. And that's something that's here in our case law. So if you can prove that you had that kind of development order that you want to challenge, that's your ticket into the door, and then you get to have the court evaluate that development order, in relationship to its conformity with the comprehensive plan, different elements, policies, and objectives within those elements. So we've also cited to one of the major cases in Florida. One of the cases that APA says is an incredibly important case nationally in terms of consistency challenges and the primacy of the comprehensive plan, that the legislature created the statute because the comprehensive plan is very important. They want any affected, adversely affected person to be able to bring the challenge. It's a much more liberal ability for standing purposes. And they want that challenge to be on any policy in the plan, because it's the plan that's the constitution, basically the constitution for land use. And it's a de novo proceeding, so the challenger gets to go to court, put on its evidence. It's not limited to the evidence that was made in the local proceeding, as you would be in a zoning challenge. So third DCA has good precedent to rely on to say that it's every part of the plan that's important. The oral argument at the 3rd District Court just took place on Monday. It's posted on the 3rd District Court of Appeal website if you want to look at the oral argument. It's actually in there are 2 sections that say archived oral arguments and another one which is live oral argument. Go to the live oral argument because you can see the judges, which gave 10 minutes to each side to argue, gave half an hour to each side because they were really struggling to understand the difference in making a challenge, to the comprehensive plan, to zoning, to consistency. And the fact is that in Florida, it's a complicated system, right? Zoning decisions can be challenged in this certiorari action, which relies on the record established at the local government. Standards are the local government failed to follow procedural or substantive requirements of land development regulations. But consistency challenges are separate and apart. The statute creates this exclusive de novo proceeding with its own standards and criteria. And then don't even get me started on constitutional challenges, because that's another thing. So courts who don't necessarily understand land use anyway, I think you could see the 3rd District really struggling with this, and I don't think that the 2nd District spent much time on it, frankly. So, see you next year.
Who's the guru on PowerPoints?
To view.
I need to get this in the slide format.
View.
Show slideshow. Where's that? There it is. That's why I'm a lawyer.
From beginning.
From beginning. There it is. Yay. All right. Good morning. My name is David Furiak. It's a pleasure to be here, and it's always great being on this panel with Nancy and Susan. They're two of the finest land use attorneys in the state. I'm going to touch upon, I hope, there we go. Anybody here like to go to the beach? Well, worst case ever, exactly. Well, I'm going to talk about customary use. Some of you may have heard about this little battle going on in Walton County about the public's ability to use the dry sand for recreational purposes. I'm going to tell you the story and kind of walk you through what's happening in Walton County, what the cases are doing, and we're ground zero right now. And it's also become an election year issue too. We've had both Senator Nelson on the beach, Governor Scott is up there. I think he realized after he didn't veto the Senate bill and invalidated our ordinance, he then remembered he was running for Senate. So he came up to Walton County. And we've gotten a lot of press throughout Florida and also throughout the country. I've had calls from all the major newspapers and news providers throughout the country because we're now on the radar that you can't walk on the beach or put a beach towel down on dry sand in Walton County. And that creates some problems. Just to give you a refresher what we're talking about, when you look at the beach, the water, there's something called the wet beach and the dry sand. The wet beach is all the dirt that is seaward and behind water. That's owned by the state. There's no question that the members of the public can walk on the dry sand. They can play volleyball, or excuse me, wet sand. They can play volleyball, they can fish, they can jog. The battle is what we call the dry sand, or the dry beach on the slide. And it's privately owned. And it goes from the mean high water line up to the vegetation line. And the doctrine of customary use addresses who gets to use that dry sand. The doctrine started in Oregon, at least in the U.S., and a case called Thornton versus Hay. And the Oregon court held that all of the beaches in Oregon are open to the public, that the public can use the dry sand, that the private landowners are not allowed to kick people off the beach. They based the doctrine of custom from medieval England, and it applied not to individuals, but to places. And in the U.S., what we actually start looking at is Native Americans' use of the dry sand moving forward. In the Oregon case, they set out 7 different elements that must be proven in order to demonstrate customary use, and they concluded that these elements apply to all the beaches in Oregon. And what's also very important is that the Oregon court held that custom is a background principle of state property law. And when we get to Florida, I'm going to circle back on that. And what that means is that the state property law defines property rights. And when we get to a Fifth Amendment analysis, that will become important when we get to Florida. Customary use doctrine in Florida. Tonorama, city of Daytona Beach, back in 1974. This is a picture of the 4th of July with folks on the dry sand in Daytona. And one of the quotes of Tonorama that's pretty significant: "No part of Florida is more exclusively hers or more properly utilized by her people than her beaches, and the right of the public of access to and enjoyment of Florida's oceans and beaches has long been recognized by this court." Notice they didn't say wet sand or dry sand, they said beaches. And then there are some additional quotes on Tonorama. I'm not going to read every slide, I just want to pick out a couple things. "The sandy portion of the beaches are of no use for farming, grazing, timber production, or residency, the traditional uses of land, but has served as a thoroughfare and haven for fishermen and bathers. The interests and rights of the public to the full use of the beaches should be protected." Again, this is the Florida Supreme Court. This slide puts forth the elements that the Florida Supreme Court established. If the recreational use of the sandy area adjacent to mean high tide has been ancient, reasonable, without interruption, and free free from dispute. Such use, as a matter of custom, should not be interfered with by the owner. And another key component of tonorama is that customary use does not establish a property right to the public. There's no question that the owner of the dry sand owns the dry sand, but there are co-equal rights of use. And members of the public aren't supposed to preclude or interfere with the private property owner from using his or her property, and the private owner isn't supposed to interfere with the public's continuing use to use the dry sand for recreational purposes. Another aspect of it is a track-by-track analysis or a geographical area. And in Tonorama, they looked at a specific tract. In Trepanier versus County of Volusia, they established that it's not a parcel-by-parcel analysis. Rather, to establish a customary right, we do not suggest that the county must prove that cars, horses, or other modes of transportation have customarily traversed and parked on appellant-specific parcels of property. We read Tonorama to require proof that the general area of the beach where appellant's property is located has been customarily used. That's a significant distinction, and we're still fighting over what is the scope of the analysis. The folks that are challenging Walton County's efforts on customary use are still trying to get the court to focus on the county has to prove parcel by parcel by parcel that the public has historically, since time immemorial, used each parcel for customary uses. Our analysis has been we're proving customary use up in a broad area, and parcels that are located in that broad area are subject to customary use. Other states have recognized the doctrine of custom. The economic impact, the economic impact of tourism in Walton County is huge. And you see some of the numbers, $2.9 billion direct impact, almost 20,000 jobs based on tourism. The county's concern is that if the public comes down to Walton County, and we have a very aggressive TDC that spends a lot of money, that invites people to come down to Walton County to use the beaches, that they then show up and try to use the beach and are threatened with being arrested. Imagine what that does to the tourist industry. Who wants to come down and get arrested? One of my nightmares is grandma in tennis shoes with a grandchild on the beach and having a CNN right there while they're getting arrested. And that's just going to kill tourism in Walton County. Let's skip over that one. So what happened to Walton County? You may have heard that Walton County adopted an ordinance. Before they adopted an ordinance, they directed our firm to investigate the factual predicate for customary use in Walton County. They have 26 miles of beach. And we hired a former state archaeologist named Dr. James Miller. He was a state archaeologist for Florida for 20 years. And Dr. Miller did an extensive analysis, months of research, and I'll walk through some of what he did. And I want to show you his work just to demonstrate this wasn't like the Walton County Commission got up on Tuesday and said, you know, customary use sounds like it's pretty cool, we'll adopt an ordinance. Instead, they spent a lot of money and a lot of time and a lot of public hearing efforts to document that there is customary use on the beaches in Walton County. Dr. Miller literally started at 3000 BC, moving forward, and looked at the middens to see what type of food was reported in the middens to determine whether it was gathered by canoes going into the Gulf or by canoes going into the Sound, depending on what type of fish he found in the middens. So he tracked use, he looked at archaeological sites from 3000 BC to 1500 AD. And you can see some of the hopefully it shows up clearly. You've got red spots, those are archaeological sites that are located in Walton County. And then every once in a while, when you practice land use law, you just get lucky. This is a painting in the Smithsonian from 1834 to 1835. And it's literally a painting on Santa Rosa Island, which is located in Walton County. And we just happen to have Native Americans with a teepee and fish hanging on the dry sand. We couldn't have gotten any luckier than this. So this is clearly one of our points of evidence that we'll be using in court. Then Dr. Miller took a look at public land surveys. When land was conveyed to the federal government, they performed surveys to establish boundaries. Beachfront patent deeds. These are the first deeds from the federal government to a private landowner. And he tracked every single piece of dirt when it first was conveyed from the federal government to individuals to see when ownership, private ownership kicked in. Obviously, until private ownership kicked in, there was nobody to kick you off the beach. So he went through all the way back to 1893, which was the first patent deed, and tracked every single conveyance up through 1956. The most recent ones were the county had acquired some property that had not been conveyed and used, so they acquired those properties for beach access and locations that actually use the beach. Here's a photo from the 1890s in Grayton Beach. Grayton Beach was one of the first settlements on the beach in Walton County. And they had people tell stories of running cattle on the beaches, riding horses on the beaches. And here's just a nice example from 1890. Jim also looked at newspaper articles. Again, we got lucky. There were two newspapers, the Funiac Herald and the Pensacola Journal, from 1906 to 1954, had basically a running series of people going to the beach. Who went to the beach? What did they do? How long were they down there? And he's got, here's just a couple samples. So over 1,000 persons are named who used the beach with a description of when and how long and what they did while they were down on the dry beach. Photos from the 20s through the 50s. Lots of the old timers that have been in Walton County 5, 6, 7 generations have provided photos to us and to the county commission as evidence of what took place on the beaches. Then Jim started, Dr. Miller, every decade from 1930, he laid out where the subdivisions were, where the roads were, where the trails were, and how folks got to the beach. And he made a huge assumption that if there is a trail over the dunes to the beach, that people were using the beach, otherwise there'd be no reason for the trail. So he's actually identified each trail that he could find going through the records. And they're based upon aerials and photographs, very extensive amount of work. Here's just a little slide dealing with the type of aerial photography that Dr. Miller used. Everything from flyovers to looking at the dirt roads, looking at structures. I'll show you a photo where you can actually see the cars parked next to the trails. So I'm assuming they parked their car next to the trail because they wanted to get to the beach. It's a huge assumption. Here's the slide that I was mentioning. The little red triangles, those are all beach paths. The blue arrows, those are cars. So he literally was able to find photographs of cars next to beach paths, demonstrating a consistent historical use of the dry sand for recreational purposes. Again, walking through, he superimposed and added the subdivisions in the 40s. You'll see more trails, you'll see more roads. Each slide, as we go through each decade, you see more intensity, more folks getting to the beach. You looked at subdivision plats, and here's an example where you actually had one that said beach reserved for the public, see Highland. 1950s, we've got more development, more subdivisions. Again, he drew the premise that if you have a subdivision on the beach, that people were trying to use the beach. This is a photograph of Dune Allen, which is in the beaches in South Walton from the 1950s. 1960s, again, more subdivisions, more roads, more trails, more access, more photographs of the types of businesses that were in existence in South Walton during the 50s. And then up to the 70s, where things get pretty much built out with the majority of the subdivisions in place. Here are some pictures of use. Folks on horses, sailboats. They used to have driving on the beaches, like at 4th of July parties. And then here's a photo of somebody actually using the beach to transport their house on the dry sand. Yeah, what's really remarkable, we've spoken with probably 30, 40 different folks that grew up there. And they talk about Walton County being a different place. That the kids would be released in the morning, they come back for lunch, They go back on the beach, and the old timers talk about going from beach Borden to Okaloosa over to Bay County and roaming the entire beach, using cardboard to slide down on dunes and flying kites. And they said, nobody ever told us to get off the beach. Everybody treated the beach as a common recreational item. And it wasn't until really recently that folks that came down from other locations and built their houses have now said, get off my beach. Dr. Miller also basically documented a series of uses that he was able to establish that historically occurred, some of which we don't do anymore, such as catching turtles and collecting turtle eggs. 10 minutes ago. Let's see, roasting marshmallows, eating watermelon, watching the stars at night. It must have been an incredible place compared to what's happening now with some of these battles. And these are just some of the uses that were documented. So what happened? Dr. Miller presented this report. We had a public hearing, so we had a couple, and the county commission adopted a beach customary use ordinance. It was done, I believe, in November of 2016, then did another one in March of 2017 because we had a work group that wanted to do some tweaks to the original ordinance. And we had some language in here that talked about the protecting the established right of folks to use the dry sand. The key here is we weren't, at least from the county perspective, creating a new right. We were protecting a right that new residents were interfering with. So the mindset was this already existed prior to folks buying their homes. And we were trying to protect the public's ability to continue to use the dry sand in a manner that they've historically used. Now, of course, after you adopt a new ordinance that affects property, I know you're surprised, we had 7 lawsuits filed against us. Federal court ranging from Fifth Amendment, there was even a claim of a Fourth Amendment, which I've never seen in a man's case before. And most of these cases, let me back up for 1 second, the Alford case was key. They claimed that the county did not have the home rule authority to adopt a customary use ordinance, that only a court, through a court action, could establish customary use. And the federal court agreed with us and said that we had the legal authority to adopt a customary use ordinance. And she had some good language in here. Just let me see what we got here. The ordinance expressly based on the county's legislative research, analysis, and testimony confirming that customary use had applied to all beaches in Walton County since before 1970, since time immemorial. And then she's just some further quotes here. Just a really nicely written decision. We were really happy with it. The Alford's challenge, they filed an appeal to the 11th Circuit, but then they did something I've never had happen in litigation that I've been involved with. They also went to the legislature. And the legislature, you may have heard, adopted House Bill 631. And 631 had one purpose, to invalidate Walton County's ordinance. So we have to start all over again. The legislature established a process that the county now needs to jump through in order to establish customary use. The legislature's argument, at least what we were told, was they wanted courts to weigh in. And we tried to argue we have 7 of them right now. Let us go through the process. We will get a court determination. In fact, we already won one of them. But that argument did not really carry the day. What's always surprised me on this, and I know I don't have too much time, the legislature enacted a bill that I believe protected the rights of probably 1% of 1%, and told the other 99.9% of the people in Florida and Walton County that don't own beachfront property that you lose. You can't use the dry sand. And I never thought the legislature, being a political body, would not count heads. 99% is more than 0.1. And there's been a tremendous public outcry, and you probably saw some of the political stuff. Governor Scott did an executive order trying to say that the beaches are still open, except Governor Scott didn't veto this bill, and this law is the one that controls, not what Governor Scott said in his executive order. And so we have a new process. We have to hold a public hearing. We have to notify every beachfront property owner of that public hearing. And then after we hold the public hearing and we do certain findings as a local government, we then have to sue ourselves. The legislature said we have to go to circuit court and file a declaratory judgment action to have the circuit court say that our evidence of customary use carries the day. But the legislature didn't identify who is supposed to be our defendant. And I know I've only been practicing for 30 years. I've always found that in order to have a lawsuit, I typically need a plaintiff and a defendant. It's really hard to litigate without both of those involved. So, although I'm drafting the lawsuit as we speak, I'm going to flip back for 1 second. I'm going to give you a little tip. I've only said this down. Legislature's good, in fact, all of people mind. When we finally decide to file this lawsuit, it's just a guess. I'll bet you some of the folks that sued Walton County, they might be named as defendants in the lawsuit. They invited us to their party, we'll invite them to ours. So we have to hold a public hearing. Scroll forward here. That's the new statute. So what do? We sent out a notice to all of the beachfront property owners. What day? I know I got 1 minute, 2 minutes.
No, go ahead.
I'm getting there. On September 8th, we held a hearing, and we had a formal notice of intent, and we had all the I's dotted on what the formal notice of intent under the statute is supposed to say. And we had about 500 people turn out. There's been over 1,000 affidavits signed by beachfront owners saying that historically that they've used the beach for recreational purposes. And unfortunately, given the property appraiser setup, apparently 12 or 13 parcels were missed. And about 100 to 150 people lived on those 12 or 13 parcels. Now, envision a county commission, your county commissioners, city commissioners, looking at an auditorium full of 500 people or more, standing with me, and telling them, oops, the notice isn't good. And we're going to have to cancel today's hearing. Yeah, that didn't go over well at all. I had 2 commissioners come to me and say, David, turn around. I can't do this. So what we ended up doing is we took public comment for 4 hours, and the vast majority of folks talked about protecting the public's right. There was probably 15 folks that said, you're taking away my private property rights, and that's going to be my final, I'm going to touch upon that as my final remark. So we took public comment, and we set another public hearing date for November 3rd. The hearing on September 8th is on YouTube. If you're bored and you want to watch a public hearing with about 500 people in the audience, feel free to do it. But the commission agreed that we did not want to give the opponents a notice issue. So we said we'll just take public comment and we'll do the hearing on November 3rd, and that will be the official hearing. Now let me circle back to what I said in my last comment. The private property owners keep showing up and telling the county, we've got now 7 law firms against us, that we've taken their property rights and we've taken away their right to exclude. If the county's right that customary use existed since time immemorial, we can take anything. They don't have in their bag of rights the right to exclude because their property was burdened by customary use when they acquired it. So we haven't deprived them of anything. Now, if the court disagrees with us, then we've got an issue. But if the court agrees with us, we believe that's the valid defense of the Fifth Amendment takings claim, because we haven't taken any property right that they had to begin with. And since property, for the purposes of the Fifth Amendment, is defined by state law, remember that slide where we talked about under the Florida Supreme Court saying beachfront property is different. And that's the other thing that the property owners keep trying to say, well, how would you like it if somebody was camping out in your front lawn or putting a blanket down in front of your house? And our response has been, we don't own a beach. We don't have beachfront property. Beachfront property by its very nature, for many, many years in Florida, has already been established as being different than your lot in your subdivision or your 50-acre farm. The beach is something different. So thank you very much.
Good morning. So I apologize for not having a PowerPoint for you. You're going to be forced to actually just listen to me, not look at pretty pictures of the beach. So my apologies. It's an honor, as always, to appear with my friends Nancy and David. Nancy's been a mentor and colleague my entire career, and you couldn't get better interpretations of what's going on in land use these days. So I'm listening as intently as everybody else, and really enjoying the ripped from the headlines nature of David's presentation. I know a lot of clients will be interested in hearing about that. As a coda to David's presentation, after that statute passed, those of us who represent local governments in Southeast Florida started getting all sorts of panicked calls. And what happened was people were just sort of reading things on their own and running to the TV stations, and the reporters were saying crazy things. And so there was a great deal of drama. And we all kind of looked at each other in Southeast Florida and said no. And, for the most part in Southeast Florida, there have been so many beach renourishment projects, which usually, although there are some statutory preconditions, will convert that to public no matter what. And in some of my communities, I even have actual easements for every single parcel. So it's more of an academic issue for many of our more urban communities here in Southeast Florida, but it is a definite issue all around the state, and even some of the Southeast Florida cities have spots of beaches where these issues arise. So, it just seems counter to what we thought this state was. So it'll be very interesting to see where it goes. So today I'm going to be talking to you about a brief overview of First Amendment, and then I'm going to be telling you a story of one of these long sagas, but rather than arising from a big decision over whether to change the comp plan, whether to go in a different direction to convert rural land to urban, these big sweeping planning issues, it's all about a sidewalk condition. So consider it a tale of how some of the most minor things that we deal with can be the spark that sets off 5 lawsuits, really 6, 42 years of litigation. And it's an interesting one. So first, more generally, looking at First Amendment, we've had pretty good coverage over the last few years at this conference because there's been a lot happening. And in particular signs, there is a program this afternoon that my partner Kathy Mahaffey and Jeff Cadens are presenting on sign regulation. So for the details, I recommend you to that. But big picture, it continues to be an issue. We continue to see challenges around Florida. As we've said previously, your treatment of temporary non-commercial signs is always going to be a target for people who would like to challenge your sign code. And if you have not yet had a chance to look at it since 2015, it is a good time to do so. We have had a number of cases since 2015 that have better defined the edges of what the change in the law that resulted from Reed v. Town of Gilbert was. And the good news that arises from those subsequent federal cases around the country is that it is still abundantly clear that it is constitutional to regulate commercial speech and non-commercial speech differently. That's a very basic premise that underlies much sign regulation, and one that has great practical consequence because in general there's not a profit motive involved with non-commercial communication. So there are many good reasons to treat those two kinds of speech differently. Also, it remains very solid to be able to distinguish between on-premise speech, that is, speech that relates to that particular property. It's a bagel shop and it says Bob's Bagels on the top of the building. Or Bob's Bagels has a political sign, that's the political speech of that property owner. That's on-premise speech. Off-premise speech is commercial speech that does not relate to that premise. You're driving down the highway, you see a billboard, pardon me, it says drink Coke, but underneath it is just weeds. There's no way to go to that particular property and engage in a commercial transaction. So that basic distinction between commercial and non-commercial, between on-premise, off-premise, which is key to billboard regulation and prohibition, temporary versus permanent, different signs in different land use categories, those all remain solid. So people who may be bringing you news of the doom of that kind of regulation are exaggerating. So that's some of the good news. The state of the law now, though, really gives you some tough choices in terms of drafting. And the bottom line is if you want to be constitutional, you end up with language that is very off-putting. I think all of us, whether we be land use attorneys or we be planners, have a value of wanting our codes to be comprehensible and to be written in a language that not only the attorney can understand, but also our elected officials, our counter staff, our applicants. The code needs to be something that is transparent to a wide variety of people. Unfortunately, when it comes to this kind of regulation, you just have to be a little bit obtuse sometimes. So a practice tip is to consider maybe having some frequently asked questions so that you can translate. And the example I would use is it's no longer legal to have a regulation of a political campaign sign, quote unquote. But you can have a regulation of a temporary non-commercial sign, which could have political speech, could have campaign speech, could have religious speech, and so forth. So, your average person is like, what? But look at things like FAQs, look at educational things where you can frame it in such a way not to give yourself liability, but to make it easier for people to cope with these changes. Some of the other good news that has followed Reed v. Gilbert is a reaffirmation beginning that very day in 2015, along with some other cases, of the doctrine of government speech. And so when you look at sign regulation in a local government, you often find sign codes where the lines have been blurred. The purpose of that zoning regulation primarily is to look at private property and private people and how they want to use their property and set out the rules, whether it be the development standards or in this case, the signs. But often you will see out of convenience, out of just trying to be complete, where there's a mixture of rules for government speech. So whether that be a traffic control sign or whether that be a sign at City Hall that identifies City Halls and things happening at City Hall, or the whole manner of government speech. After these developments in the law, it's very important to keep government speech in its own world, separate from your zoning regulation, because the government is not subject to the First Amendment, to broad discretion. You can even censor. You start to put that into your sign code, you really start to blow those lines. So those are the good news areas. The not so good news areas are where these cases have been used to look at the issue of solicitation and panhandling, which is a very difficult issue that we all face in our communities. And if you want to just generalize, after 2015, any rule that attempts to prohibit or regulate solicitation or begging or panhandling is pretty much dead in the water. There were about 15 cases in the 2 years after Reed v. Gilbert. All but one were negative and struck the rules. And the only one that was upheld was a very unique case around a baseball stadium, very cramped area, true safety issues involved. And not for lack of trying, a very creative city attorney up in the Northeast had tried to come up with 10 different kinds of aggressive panhandling. And the court's reaction to all of these efforts has been, yeah, if this person's doing something they shouldn't, then cite them for doing that, whether that be assault, whether that be battery, whether that be false imprisonment because they're blocking the sidewalk and preventing you from passing, whether that be trespass on private property. Those things exist in our laws, and they have a long time, and by all means cite, but don't give additional legal meaning or consequences to that person simply because they committed these offenses in the process of attempting to express an idea. And the courts have said that whether you hold up a sign or you simply hold up your hand or and empty coffee cup, that is an expressive act, therefore it's protected by the First Amendment. Therefore, it cannot be the occasion for legal jeopardy. So that's the bottom line on solicitation and panhandling. Very, very active in the years since 2015. Our LUPA continues to generate many cases. For those of you who follow these issues more closely, you know that that's the Religious Land Use and Institutionalized Persons Act. It's this sort of forced marriage, shotgun marriage of the rights of prison inmates and the land use rights related to religion. And similarly, the FHA and the ADA are yielding significant amounts of activity. In general, as a practice pointer, if you do not have a provision for reasonable accommodation in your zoning code, and that is an administrative procedure separate from your typical variance that allows someone to come forward and say, I don't care if I have a quote hardship or not, I have a federal right that you're violating, and that's the reason why your zoning should not be applied to me. If you don't have any of those written into your code, you should definitely consider adding it to protect yourself. It's an active area. And then finally, to the story that I promised you. I have about 15 minutes. So this is a case involving a condition on an administrative site plan approval to build a sidewalk. It just sounds very minimal. It sounds like everyday thing that you would not even think twice about. But it led to quite a lot in this particular situation because we're dealing with urban infill and redevelopment. And so in those situations, sometimes small things mean a lot. They become the hook by which people try to express their concerns. And this story is based on the court opinions. I'm sure there are probably some people here who maybe know something about this case, and there may be more facts, but this is what the courts have found. So we're talking about Northeast State County and a city there called Aventura, and there are 3 islands. And there's Williams Island, the North Island, and the South Island. And all the way back in 1976, we had our first litigation where the developer sought to develop, and the county lost a lawsuit, and the court ordered the county to approve a rezoning. So that was the 42 years of litigation. Many years later, because there wasn't an immediate move on North and South Island, we had the platting of these 2 islands, and then this area, which had originally been unincorporated county, was incorporated as a city, and the city did recognize the vested rights from the prior county approvals. So the city comes along in 1998 and is asked to, and does approve, an administrative site plan to develop the South Island with like estates. It's a small island, 21 homes and a marina. They're single family. It's a very nice, surrounded by water, basically in their coastal. There's a bay there, but it links into the intercoastal. Nice place to be. And the city said, but we do have one condition. Because this other island, the North Island, is undeveloped, and the only way to get there is through the South Island, we're going to allow you to build one side of the sidewalk, but not the other. If you ever come back and develop the North Island, you've got to build both sides of the street. So the houses get built, the people move in, and life goes on. And there's a 10-foot utility easement on each side of that street. The vested rights are recognized by the new city for a combined total of 24 acres on both islands. 408 units were permissible under the county approvals. So we had 22 homes. Obviously, there are a lot of rights left over that could potentially be placed on that North Island, but the only way to get there is through the South Island. So fast forward, and we have the person who is acting currently as the developer, who has the controlling interest in many of the development entities, the remaining vacant lots, and in the North Island, who's also serving as the president of the Homeowners Association for the South Island. And as he starts to talk about developing the North Island, some of the residents are like, yeah, we'd like access to amenities when you do that North Island development. Oh, here, sign this agreement. By the way, you're waiving all your rights to challenge development of the North Island, and I'm going to sign the agreement on your behalf because I'm the president of the Homeowners Association. So clever, but So along the way, we end up with a lawsuit with the Williams Island owners, but they settled out. So they had challenged the vested rights and they dropped out. So the main fight is over what happens with this North Island, which gets approved for 160 units, pretty modest compared to what the rights were, two 15-story towers with height of 201 feet. But if you own one of those 21 island homes and all of that traffic is going to be coming through, you're not so happy. So in order to proceed with this project, remember that site plan condition? If you're going to build on North Island, you got to build the other side of the sidewalk. They can't pull a building permit. They can't close on their construction financing. They can't do anything until they build that second sidewalk. So they get 12 out of 15 homes, no problem. The last 3 homeowners decide they don't want to let this happen. And so that's where these issues arose. Originally, those 3 homeowners sought a temporary injunction in court against the construction of the sidewalk based on the fact that it affected their lots and there was no demonstrated easement or right to affect their lots. And the trial court agreed with them and granted the injunction, but he refused to allow the developer to participate in the litigation. So the developers could not go forward, they were dead in the water because they couldn't complete the sidewalk. And the homeowners were only told they had to pay bonds of $20,000 each for this injunction. Normally, you have bonds that accompany an injunction that are supposed to approximate the potential damage if the injunction is wrongfully entered. So that was pretty much on the low side. The appellate court, though, decided that this injunction was improper because it interferes with the developer's rights and they weren't even allowed to be part of the proceeding below. And the appellate court also found that this injunction had delayed the receipt of the building permit, it delayed the sale of the properties, there had been substantial pre-sales. So basically, homeowners, yeah, you won in the trial court, but you lost in the appellate court. The very next day after that, the developer's out there trying to build the last 3 lots of the sidewalk, and that's where it really gets interesting. They run to court in the morning and try to get relief, and when those homeowners are unsuccessful in doing that, they start to physically block the area in which the sidewalk is going to be constructed with parked vehicles and with people. Apparently, like the gardener and the maid were ordered to sit on top of the car so that they could not go there. Apparently, one of these homeowners had to leave for a time and come back. The fresh poured cement was there along the edge of her property. So she has her husband drive the big SUV through the poured cement while it's still wet in order to destroy the sidewalk. But the developer's agent is nearby who sees this. Everybody calls the police. And the homeowner is arrested for criminal mischief, disorderly conduct, and resisting arrest, and claims she was injured in the process of being handcuffed. Basically, they lifted her off the ground 30 or 60 seconds and she had a shoulder injury. She was released on bond the next morning. So the development proceeded because remember the appellate court said, yeah, you can go forward. The injunction is lifted. So at that point, they're continuing to do more pre-sales, $222 million in sales with $63 million held in escrow. And of course, the delivery of the units is being delayed on that North Island. So the developer turns around and sues the homeowners for $30 million, claiming that these agreements that were signed on behalf of the homeowners association by the developer bound them, and therefore they had waived their right. There were a couple of different counts related to that. Also account for slander of title. Basically, that the homeowners were going around talking to prospective buyers and telling them it would never get built and trying to interfere. And then there was also a tortious interference claim. So these are where we get our signposts in the law, where the issue is accompanied by enough resources for people to fight out every little detail. And that was clearly true here. There were parties everywhere, all represented by different attorneys. So all of these claims that the developer filed against the homeowners were dismissed by the trial court, saying, look, if you want this to have the effect of a covenant against these individual lot owners, you can't sign on their behalf as the HOA president. They have to have agreed to the impact on their property. Moreover, the homeowners defended under a statute that we have that is an anti-SLAPP statute. And I think most planners are familiar with the concept of SLAP. It's a strategic lawsuit against public participation. You hear about it in planning school or throughout your career, but it's actually pretty rare to see reported precedent on what the SLAP statute means. And just to give you a sense of what the statute's about, is to protect the right of parcel owners to exercise their right to instruct their representatives and petition for redress of grievances before various governmental entities. So that's not just your local government, that's also the judicial system. Those rights are First Amendment rights. So this really is a First Amendment case after all. And the legislative intent finds that these SLAP suits have occurred when members are sued by individuals, business entities, or governmental entities in a way that arises out of the parcel owner's appearance and presentation of their rights before this governmental entity, whether it be a local government or a judge or some other form, on matters related to an HOA. Well, this clearly was related to an HOA. And it is the public policy of the state that these individuals not engage in SLAP suits because such actions are inconsistent with the right of parcel owners to participate in government. And so it goes on and it provides for basically a speedy resolution of the case. It also provides for actual damages that may be trebled by the court, so 3 times the amount of actual damages, and prevailing party reasonable attorney's costs and fees. So the trial court said, yeah, this applies. Section 720.304 of Florida statute applies. This was a SLAP suit. These homeowners have the privileges under this statute. So before, and this all happens orally, which isn't often the case in court. So the judge is telling the parties, this is my ruling, this is my finding. Before that is reduced to a written order that could be recorded with the clerk, the developer's attorneys run and file a voluntary dismissal of the case without prejudice. The trial court is like, hell no, and enters a written order, yes, I dismissed your case with prejudice, you're wrong, and they appeal. And guess what? The developer was right, because there is a privilege to be able to voluntarily dismiss your case at any time prior to that formal final action. So, but the appellate court did agree that the homeowners were not bound by the agreement, that part was upheld, and they also agreed with the SLAP statute finding. So the tortious interference claim was barred though. That was something that you have a right when you file a lawsuit to say things about the subject matter of the lawsuit without being liable for saying those things. The claim for slander of title was allowed to proceed. So we have a mixed outcome here. The developer's winning some things, the homeowner's winning some things. It gets better, because there's another 2018 decision in federal court this time, where, remember the homeowner who didn't like being arrested and said she was injured? So we have a suit against the city police officers for excessive force and arrest. A couple of weeks ago, we had a decision that they are not protected by qualified immunity. And so that case is going to move forward. And it's because it was at a motion stage. There may well be facts that ultimately she will not prevail. Her version of the facts are she was completely reasonable, she did not resist arrest. You know, the police officers have a little bit different version of it, but because of how the litigation was postured, they could only look at her view. And here's the final coup de grace. This woman is running for city commission this fall. So that's your story of how the sidewalk condition can lead to 42 years of litigation. Thank you for your attention.
Well, we're at the end of the scheduled time. If anyone has 1 or 2 questions, I think we can answer those or try to answer them. Yes, sir. Repeat the question.
It's on.
I believe your question is, does the Walton County hearing that's coming up in November pertain to the entire state or just Walton County? It will only apply to Walton County. The customary use analysis is site-specific to each local government. So there won't be a precedential value, for example, if Walton County wins to somewhere on the East Coast or the West Coast. But the template that we're using definitely could be followed. Absolutely, the gentleman's indicating that apparently property owners put shrubs down the mean high water line. And oh, perpendicular, yeah. Well, we're having similar stuff in Walton County. Some of the homeowners associations have hired armed guards. There's actually a memo that's been drafted by an attorney representing one of the sheriff's office that the property owners can use stand your ground. And yes, they need a lawyer.
Any other questions? Time for one over there. Yes, ma'am.
I was wondering if we could get a repeat on for the administrative procedure for the relief of what exactly was that?
So what I'm referring to is something called a reasonable accommodation. Sometimes we've called it a zoning relief, but conceptually, you're writing a new procedure into your code. And it is in addition to and separate from your classic zoning variance based on hardship. And the purpose of that procedure is for someone to say, to file a piece of paper and say, I should not have to follow this part of your code, not because I have a hardship, but because I have a federal right not to follow that part of your code. So whether that be a First Amendment protected use that maybe is claiming that it is protected, whether it's an Art Lupa protected use, a church that wants to do something that believes that Art Lupa protects it, if it's a sober home or treatment facility that's claiming protection under the FHA or ADA, there's a number of different federal theories by which we are basically subject to the supremacy of federal law, and it's not valid for us to apply our zoning laws, even if they would apply in every other circumstance. So if you create this administrative procedure, there is, I don't know that it's 100%, but I continue to argue that they have to exhaust that. They have to give you the opportunity to do it right. And so it is, it's an insurance policy that you know that somebody believes their federal rights are being violated before you get the federal lawsuit.
Okay, well, thank you, everyone. Enjoy the rest of the day.